submitting that one as well. The other one is Carwile, Carwile, and that is as it relates to allegations for intent. That is an aggravated child abuse case, so it is simply a case about when it is, and it's a JOA case, so as I said, I'm not sure it's directly opposite, but I think it does point out that the court's question before we left was as to the intent, and the intent is the same for the same act, that is the shooting. That is an intentional act. It's not a separate intent that's required. So I just want to make sure I was clear. I think the other cases also make that point, but Carwile, I thought, might be instructive along those lines, and if it isn't, it isn't. But Harrington was the principal one, and I just want to make sure that the court was aware that I brought those up.
Okay, thank you. Defense?
Well, likewise, as the court, I just got these cases as we came in here a couple of minutes ago. I certainly haven't had a chance to read them or do any follow-up.
I don't need you to do that. I went back and I looked at all this, and I don't think that the evidence supports a charge to the jury for third-degree felony murder on a child abuse charge. So I'm not going to give that instruction. So I have received your final draft, so it's not so final yet. The change that would need to be made is on the lessers to take out the third-degree felony murder. And then we can just excise out the charges, and and you'll finalize the verdict form.
Yes, sir, we will.
I understand your argument, but I
was only going to ask which part of shooting a child hadn't been established.
Well, I just don't think that the intentional part of that is there for the child abuse charge, and it's not alleged in the information that way. And I just don't think that the evidence supports that. And if I'm not sure about that, I'm not going to charge the jury on it. And I think that to exercise caution, I'm going to deny that being